Hello and welcome to July's edition of Outline, DLA Piper's regular series of planning law webinars. Today we're talking about the topic of permitted development rights, and I'm joined today by one of my fellow partners in the planning team at DLA Piper, Sophie. So welcome to you, Sophie.
Thanks, Trevor. Good morning, everyone.
And so just in the usual way, we will keep ourselves to within an hour, hopefully comfortably within an hour, but with an absolute maximum of an hour, so we don't detain anyone for too long. The Q&A function is available for those watching the live broadcast. So if you do have questions, do please pop them in the chat, and we will do our best to answer as many of them as we can. But without further ado, let's kick off. So permitted development rights, a topic which is, to my mind, sort of quite often overlooked in a legal sense, partly because lawyers quite often aren't involved. When PD rights are being used, it doesn't normally end up on a lawyer's desk, but there are a number of legal issues that come out of it and a number of traps and pitfalls. So we thought it'd be useful today just to look at some of those and raise awareness of some of the challenges. But I think probably the best place to start for me is just to remind ourselves of where it sits within the system. Under the Town and Country Planning Act 1990, there is a requirement that anything that constitutes development, as defined in Section 55 of the Act, requires planning permission. So if what you're doing isn't development for the purposes of the 1990 Act, then you never need to think about permitted development rights, because it doesn't need planning permission to start with. And that's sometimes people run to looking for a PD right to allow them to do something, when actually the answer is you don't need it, because you don't need planning permission. So things like, for example, internal works that wouldn't constitute development, you wouldn't need planning permission. So it's only once you're carrying out development in a 1990 Act sense, and of course development in that context includes material changes of use, but if you're carrying out development, that's the point at which you need to think about whether or not there is a permitted development right. There is a need for planning permission. If there's a permitted development right, then subject to complying with the requirements of that particular PD right, you don't need to apply for an express grant of planning permission, but it is a planning permission in its own right. And that's conceptually, I think sometimes, Sophie, we forget that, don't we? We can blur the boundaries a little bit between it.
Yeah, that's right. It's a planning permission granted by a development order. And interestingly, I think the point that's really important to remember, and actually it came up quite recently, is if you're looking at enforcement situations where you're reverting to the previous lawful use, it's not lawful by virtue of long user. Once permitted development rights have been exercised, it is as if a planning application had been granted. So it puts development carried out under PDR on the same footing. And I think you're right. It's important to remember the fact that it is a planning permission, A, for the reason you've already set out around, is planning permission required in the first place? But B, because a lot of the considerations that need to be looked at when carrying out development or in enforcement situations, or when you're carrying out due diligence on purchase, are the same for development under PDR as they would be under development under a specific planning permission granted on the basis of an application.
Yeah. And for a long time, PD rights were pretty uninteresting. They were what they were. They were what they'd always been, and nobody really worried about them too much. But I think certainly since probably 2015, maybe a little bit before that, but we're now working under the Town and Country Planning General Permitted Development Order of 2015, and we really saw it was the coalition government, to my mind, that sort of suddenly started to use permitted development rights as a tool for delivery and a tool for trying to kickstart growth post the global financial crisis, and so we've seen an increasingly frequent meddling with the PD rights. And that's been the introduction of lots of new PD rights that are very wide ranging. The classic example being what was originally conversion of office to residential, but is now sort of more broad with the changes to use classes order. And we'll come on to talk about that one, I'm sure, in a bit. But we've also seen sort of tinkering with those rights afterwards. So although we're dealing with the 2015 order, there have been a number of amendments since 2015 to tweak the system and to add to and sometimes take away from the permitted development rights that we have. But I think probably the first place to start would be in terms of limitations. There are limitations on the use of PD rights, and it's important to keep those in mind because some of them are not always obvious. And I suppose the first one, Sophie, would be kind of Article 4 directions under the order itself, wouldn't it?
I think Article 4 is a great place to start. But actually, I'm going to roll back to a step before that because I think there's a point, and it's you're right. Sort of we've seen the growth and the tinkering since 2015, but obviously PDR has been around for a long time. Going way back to the 1960s, when it was actually established that the permitted development rights are enshrined in statute. They're enshrined in secondary legislation, and actually the primary limitation on them is that you have to fall squarely within the PD right as described. And I think that's the kind of the first thing you need to remember, because that is a bit of a divergence from planning permission on applications, where you've got obviously a description of development. If you go beyond that, it doesn't necessarily invalidate what you've done within the description. Whereas with a PDR, if you go out with what you're allowed to do, all of the development purported to have been carried out becomes unlawful. So I think that's probably like the first limitation, if you like, that you've got to stay squarely within the confines.
And that's the Garland case, I think, in particular, back in 1968, which made the point in that case. I seem to recall it was an extension, I think, to an existing residential property, and it went beyond the PD rights. The council had sought to take enforcement action, and one of the points that was made by the appellant challenging the enforcement action was that the enforcement notice required the removal of the whole of the extension. And the appellant said, well, actually, the enforcement notice only ought to take it back to the extent to which we could have built this extension under PD rights. And the court was very clear, no, you're outside of the PD right, therefore the whole of the development is unlawful. You don't sort of get to bank the PD right and then chance your arm on whether you can get away with the extra. So yeah, you're quite right that there is a limitation, which is that it absolutely has to sit within the limits that are imposed on the particular permitted development rights being exercised. And I suppose a sort of secondary point there, other case law more recently has confirmed that when you're interpreting those limitations, it isn't the same as interpreting conditions on a planning permission or other planning documents, because it's statute. And therefore the rules of statutory interpretation apply rather than the sort of the rules that came out of the Supreme Court's decision in the Trump case as to how to approach the interpretation of other documents. So within that clear statutory interpretation framework, there's quite a literal approach will be taken to what those limitations are. And if you don't fall squarely within them, then, as you say, you're quite right. There is no planning permitted development right.
And actually, that links us quite nicely back to Article 4, because following Trump, Article 4 directions are actually interpreted in following the rules for public documents that were discussed in Trump. So again, a little bit of a divergence that when you're looking at the two and you're looking at, does a PDR right apply and has it been removed, whether by an Article 4 or by a condition, the interpretive rules are actually slightly different between the two, which I think doesn't quite square the circle, but does drop us back at Article 4 directions, which of course are instruments of themselves which can be made by local planning authorities with a view to remove permitted development rights. Generally, they are not used as a blanket, thou shalt remove all PDR forevermore over a particular area or a particular site. They're focused on specific classes. The most common use I think we see at the moment, and particularly down in London and other large urban areas, is the removal of office. Well, it's not just office to residential anymore, is it? It's Class E. So commercial uses to residential developments. But they are put in place. They do remove permitted development rights where they exist. Putting them in place is not a quick process. They do require policy backing in the same way as sort of any supplementary planning document that sits and forms essentially the development plan to control development in an area. So they are consulted upon. They are put into place over a period of time, but they are something that needs to be aware of, because once they are in, they do remove that PDR from the area over which they take effect. If they are being proposed to be brought in, they can be challenged. We had some success last year actually getting a property removed from a proposed Article 4 direction on the basis that the policy basis that the Article 4 was being promoted on didn't apply to a particular set of buildings. There was an obvious sort of exception, and the Secretary of State did amend an Article 4 direction to remove some buildings. So it's not sort of, if you have a portfolio and you have some aspiration that you think PDR might be useful in achieving those development goals, the fact that an Article 4 is there or is coming forward isn't necessarily the be all and end all to removing the PDR and requiring a planning application. But if you are aware that one is being promoted and brought forward, I think it's always a good idea to come and consider in the round whether properties can be removed or there's any ground, because once it's in, that's it, the PDR's gone.
Yeah. And I think just a sort of final comment from me, perhaps on Article 4, there's an interesting case, the Berkshire Assets and Hounslow case, which looked at a particular direction. It's your point about how you interpret a direction, and the direction sought to disapply the Class E to Resi PD right. It excluded from the direction any building or land that already had the benefit of prior approval. Now, I think what the council had intended, certainly the position the council took in the litigation, was that only applied to prior approvals that had been granted before the Article 4 direction was brought into effect. What the developer tried to do there was to submit a further application. They already secured one, but then applied for further prior approval post the introduction of the Article 4, and the local authority Hounslow said no, you can't do that because of Article 4. The court disagreed, and what the court said, applying that statutory approach to interpretation, is no. The direction's wording was any building or land with the benefit of a prior approval. This building has the benefit of a prior approval, therefore the building is excluded from the Article 4 direction. What the court said was, if the council had intended to exclude any new application, then it should have said any development with the benefit of prior approval rather than any building or land. So quite a technical, and it's unusual in planning because courts don't tend to like to get legalistic when they're interpreting planning documents. So I think anyone drafting an Article 4 needs to be careful and needs to make sure they're getting good legal advice, because it will be approached in a very legalistic way. But equally, if you're looking at whether an Article 4 direction is limiting your permitted development rights, again, it's worth quite a forensic analysis of what the Article 4 direction says. How has it been phrased? Because it may be that it's not successfully doing everything that on the face of it might purport to be, or the local authority might think it's doing. So they warrant some careful legal analysis, I think.
Yeah, I think that's right.
There are sort of various other ways as well, aren't there? There are individual permitted development rights are themselves, they can exclude certain situations. Some of them either don't apply or apply differently in conservation areas, listed buildings, national parks, all sorts of different areas. Yeah, so it's always important to look at the limitations on the particular PD right as well to see if it's disapplied. But I think the one that is probably the source of most litigation in this area of whether they apply or not, and the one that can often get missed, is a grant of planning permission, express grant of planning permission, can itself disapply PD rights. And you will frequently, I think, see a condition imposed on a planning permission that purports to exclude permitted development rights moving forward. And those, quite often, they're sort of waved through as fairly standard conditions. And I think developers need to think very carefully around whether they're going to accept that condition, because it does have an impact moving forward. And sometimes it's not expressed in terms, and the courts have frequently held that it doesn't have to say permitted development rights are disapplied. A condition that says something to the effect of, not to be this building can't be used for anything other than what it's granted permission for, can have the effect of disapplying those permitted development rights in terms of changes of use, at least. So I think careful analysis of conditions on extant planning permissions to see whether they themselves limit the ability to use permitted development rights going forward. And I suppose also bear in mind the MPPF and the MPPG are clear that whilst these conditions are quite often sometimes sort of treated fairly standard and imposed without much thought, they shouldn't be. National policy is clear that they should only be imposed when there is a legitimate planning reason for doing so. I think government tends to take the approach that their default position is permitted development rights should apply to new development in the same way as it does existing development. There needs to be a particular justification for imposing those sorts of conditions that limit. So there's a lot of litigation in that area, I think, Sophie, isn't there? It gets complicated in both directions.
It does. I think a good starting point is the Court of Appeal decision in Dunnett from 2017, which actually looks at that point around, does wording need to expressly refer to the GDPO or the GPDO, permitted development order, in order to remove PDR that's been granted, or can it be interpreted in such a way that if that's the obvious intention of a condition to remove those rights, should it be read that way? It contains some good examples in that case as a starting point. You're right, you tend to see it most change of use, and also in residential development, where quite often you'll see limitations on, for example, turning integrated garages into habitable rooms, usually justified on parking and highways grounds, that obviously do limit PDR, but then of themselves also have an impact on asset value as a result. Because you're quite right, obviously PDR is there as a national policy point, that there are certain types of development for which planning permission has been granted. It's been granted at a national level. The government has decided it's acceptable, and therefore seeking to limit that should be robustly justified. And I think where a condition expressly refers to the permitted development right order, we tend to see that on decision notices. Thought is given in the reason, but where quite often you have a condition that doesn't necessarily expressly refer to removing permitted development rights, but does so by its operation, quite often the reasons are much less robust. And in those circumstances, then absolutely consideration ought to be given to an application to have that condition removed post-grant under Section 73. And it's a tricky one, because it's also the case that quite often, particularly with complex and older development that has through the years, perhaps a large industrial park has been developed, but then individual permissions have been sought for various things over the planning units within that, over individual units, or even common areas to change things, having to go back. And actually, if there's an overarching site-wide permission that part of the site, that is still the operative provision for, consideration has to be given as to actually whether the subsequent grant of a planning permission without that condition attached, for example, a change of use within an individual unit that is unlikely to replicate those conditions from the operational development permission, does that mean that condition still bites? And does that mean that the PDR is still removed, or have intervening events led to that condition no longer being relevant? It's that straightforward.
it's that question that we've talked about in a previous episode around sort of the Lambeth case. But other than the Lambeth complication, actually, it can become quite important if you're looking to use PD rights to be clear on what is the authorising permission as at the date you're looking to use those PD rights, because that big outline planning permission might have included restrictions, but if you've subsequently secured other standalone permissions or even a Section 73, and that condition hasn't been carried through, then potentially that restriction has fallen away by omission. And only in the sort of limited circumstances of Lambeth would that not be the case. So yeah, it's a rabbit hole we don't need to go down today, because we're talking about PD rights rather than planning conditions and Section 73 in Lambeth. But it is certainly one to think about if there are multiple permissions, some of which disapply PD rights and others that don't. If you're looking to try and use PD rights, then actually there is an opportunity to sort of that thorough analysis may give you a way through, even if on the face of it there's a condition preventing the use of that right.
Yeah. And that's actually where another kind of tool in the planning arsenal comes in. And again, going back to the first thing we said, PDR is planning permission granted pursuant to a development order, and therefore all the tools are generally available to it. And that's if there is considerable confusion or any doubt, a certificate of lawfulness application can still be made in respect of prospective use of permitted development rights to remove that question. And that's that's another tool, a fairly quick tool that can be used to give that certainty, but particularly if you're looking at exercising one of the classes, like the Class E to Resi conversion, or Class Q for agricultural to Resi, that actually has quite a large capital expenditure attached with carrying out the works. So it's a good way to get certainty up front.
Yeah. One of the sort of things that's been part of the development of PD rights in the last sort of decade or so is the introduction of the prior approval process, or perhaps more particularly the prior approval processes, because there are a number of them. So you always need to make sure you're following the right prior approval process for your particular PD right, because there are differences in the prior approvals. But a number of permitted development rights do now require prior approval. And that is an area where there are a number of pitfalls that I think are worth exploring, and where you see quite a bit of litigation coming out of it. The first one for me, I think, is the time scales. It's a two-stage process. You have to notify the planning authority, and the planning authority then has a period of time in which to tell you whether they require prior approval to be sought or not. So you don't automatically have to need prior approval. The local authority gets to choose whether they can kind of wave it through, or whether they want to have closer consideration of the particular matters that are relevant to that prior approval process for that PD right. The sort of local authorities need to be alive to the fact, if they don't respond to that request for confirmation as to whether prior approval is required or not within the period set out, then it is deemed that the local authority does not wish to need prior approval to be given, and therefore the applicant is able to carry on without going through the process. So sort of local authorities in particular need to keep an eye on that, but actually so do the applicants, because if the local authority doesn't do it, then you've got a free pass and you're away. So it's worth keeping your eye on it. With that time limit, and with the time limit for determination of prior approval if it's necessary, I think it's worth bearing in mind that they are both capable of extension by agreement. And the case law has settled that. There was an argument in the early days as to whether you could extend the first of those time limits, but the courts have said yes, you can. That agreement, as with extending time limit for determination of a planning application, that the requirement is that it has to be in writing, that agreement. But interestingly, the WLUK case, which was Court of Appeal decision in 2020, WLUK sort of slightly fudged that, where in that case there'd been a discussion where they'd agreed with the planning authority could have more time to consider whether prior approval was required. The applicant had then followed up in writing to say, just confirm, we'll give you more time. But the local authority had never replied, never confirmed in writing. that was agreed. When it got to the 52-day limit, the developer then said, "Oh well, you haven't determined you're out of time," and argued that there had been no agreement in writing because the planning authority hadn't responded. Now, in that case, the court said, actually, no, this is enough. It's a record that agreement had been reached. The planning authority didn't come back and disagree, and therefore the court was prepared to accept it. I think, though, I always say when talking about WLUK, I wouldn't rely on that. I think, for both parties' sake, if there is written agreement, or if there is an agreement to extension, an email from one party proposing it and another party confirming it just puts the matter beyond doubt, rather than getting into the sort of situation that happened in the WLUK case where you're arguing about evidentially was there written agreement or not. So I would encourage everyone, if you are extending those periods, do it in a bipartite exchange of emails so that both sides have confirmed their agreement in writing, and then there's no uncertainty as to whether it was or wasn't extended.
Yeah, and I think that's really, really important as well, when you look at how that sits with the Keenan case as well, which again is kind of a limitation on PDR. But if prior approval has been determined to be required, and if it hasn't been granted, or if you've not fallen outside of the deeming timeframes, then if you start development, you're outside of the permitted development right as well. So that's really, really important to avoid any future argument as to whether, particularly a local planning authority considers a time limit's been extended, you consider it hasn't, you start work. And then actually, if the developer's found to have been wrong, they can find that everything they've carried out is actually unlawful because it's not within the scope of the PDR. And the other point there is the Winters case, which very much firmly put the emphasis on the word prior. It is a prior approval. It cannot be applied for retrospectively. You can't start development and then realise actually one of the prior approval processes should have applied. Even if you put the spade down, so to speak, you can't then go back and apply for approval of what's already been carried out.
Yeah. The interpretation point again, isn't it, is applying a very literal approach to what the words say. You can't have a prior approval that isn't prior. But it is a really important point because the most minor start on site is enough to mean that PD right is no longer available to you. You've got no choice then but to go for an express grant of planning permission, a planning application. So I think that's a key point. And interestingly, the case law on that also looked at the point in that case, what had happened was the planning authority didn't respond to the request for prior approval. And so the applicant said, well, actually, I'm now deemed to have my prior approval. The court said, no, the local authority is not under an obligation to respond if you're trying to use a PD right that you are not lawfully able to use in the first place. So the fact that they don't respond doesn't somehow allow the PD right to crystallise if you started in advance. You started before you applied, therefore the local authority is under no obligation to do anything. And if they just choose to ignore you, that doesn't mean you've got away with it. You're still carrying out unlawful development that's liable to enforcement action, and would need a retrospective planning permission potentially to resolve it. So that making sure you've got your prior approval before you start the work is critical, far more critical than actually if you're applying for a planning application. Yeah. Where I suspect, Sophie, you have clients the same as I do who might not have waited until the ink was dry on the planning permission before they put a spade in the ground. That is fatal if you're dealing with permitted development rights that require a prior approval process.
Yeah, it's fatal for the fact that you're then out with the PDR, and your enforcement action, as we've already said, isn't going to be a scaling back exercise. It's going to be a remove entirely. But also for a point that came out only a couple of years ago as well, which obviously, if you go through the prior approval process for any of the classes of PD rights, the local authority has the ability to attach conditions to those prior approval decisions. Again, kind of the coming together of the two processes. Section 73 is available as it is on a permission granted by an application to challenge those conditions. But there was a case in 2022, Zenith, which was a change of use PDR. The prior approval was granted for the change of use, but actually a condition that was put on that permission for the so again, it was Class E to residential PDR, a condition that to protect the amenity of the new residents that were coming in. The windows in the building needed to be changed wholesale. That fell out with the permitted development right for the change of use because it constituted operational development that didn't otherwise benefit from a different PDR. Therefore, there was a condition on there saying before you can use the change of use PDR, you need to go and get planning permission to change the windows. And that would have been an application for planning permission of itself. So again, then if you'd have undertaken the actual change of use before you'd got the planning permission for the new windows, and that had been carried out, you would have been in breach of a condition attached to essentially a planning permission, albeit one granted under a development order. And again, you'd have found yourself potentially out with the scope of the PDR, but under general planning principles, you would have commenced development in terms of the change of use without complying with a true condition precedent, pre-commencement condition, and therefore the development undertaken under sort of ordinary planning law principles would have rendered your change of use unlawful as well. So it's really important where prior approval is required that you wait to see what that decision looks like as well.
It's a really good point, and it kind of takes us nicely into E to C3. I'd have thought that we keep talking about and saying we'll come back to that. We'll come back to that. So probably need to get to it. But just before we do, so we will come back to it one more time. I think one of the other points that comes out of the case is actually it's the Berkshire Assets case I talked about earlier, the Hounslow case. But one of the other points that came out of that was, what do you do if prior approval is refused? And what is your step? Because it was arguably wasn't clear at the outset. The answer is it's effectively a refusal of planning permission, and therefore a Section 78 appeal is the way to deal with a refusal of prior approval. There had been a suggestion that you would go straight to the High Court, effectively judicial review, use the Part 8 procedure and judicial review to resolve it. But the court in that case said no, because if prior approval is refused, then you have had planning permission refused, therefore you're well within Section 78. So the route through a refusal of prior approval is a planning appeal in the same way as any other refusal of planning permission by a local authority. So I think that's just another one to sort of talk about in the context of prior approvals. But that sort of does take us on, I think, to E to C3, which I think is... It's one that it's probably the one that's been most commercially valuable to certainly our clients. It's the one that the larger, more institutional landowners have probably seen as being most relevant to them. Prior to office to resi conversion, it was very much sort of barn conversions and sort of extensions to residential properties and statutory undertakers and people who worried about PD rights. But suddenly, the very biggest landowners and institutional investors have started to engage with PD off of this. So as a result, it seems to have a very high profile. It's also one of the ones that's been very controversial with local authorities because it goes against quite often policies that are seeking to retain office, seeking to retain employment space. Now that it's E to C3, policies that are about sort of town centre protection, retail offering, and that sort of stuff. So it's the one that probably is the one that's most valuable to the average landowner, but the one that's possibly the most controversial and the most unpalatable to the average planning authority. And it's taken a while. I'm not sure we're quite there yet, but it's taken a while to sort of find that, everyone to get their head around the fact that this is a change that's here, whether subject to Article 4, whether local authorities like it or not. Mm-hmm. But I think one of the key things for me in it comes within that broader section of permitted development rights, which deal with changes of use. And so I just want to start there, I think. And it kind of probably start with a bit of a repeat of the point I made at the very beginning here. Not every change of use requires you to run to the permitted development order in order to check that you've got a PD right. It is only if the change of use is material in a Section 55 sense and therefore constitutes development. So the most obvious example, changes within a use class are expressly not material. And so you don't need a PD right to move within a use class. That sort of is probably point number one. But if you're outside of that, and if the change of use you're making is material, then there are a series of different permitted development rights within the order, of which the most high profile, as I say, is E to C3, and that's the one with the biggest effect. But it is just a permission to change the use. And it kind of ties in with what you were talking about with the Zenith case, I think, Sophie, doesn't it? It does not authorize and a prior approval, a sort of change of use under the PD right for E to C3 cannot authorize any works that are themselves operational development. Now, that's not a problem with internal alterations, because internal alterations aren't development, therefore they don't need planning. So if all you need to do to convert your building from E to C3 is to get a change of use permission and make internal alterations, then the PD right gives you everything you need. But that is quite unusual in my experience. Usually something needs to change externally, whether that's changes of windows, which was the case in Zenith for amenity issues. Increasingly these days, compliance with Building Safety Act, other external alterations that need to be made in order to facilitate those changes. Then you need to be looking at a planning permission, an express grant planning permission, not for the change of use, but for the operational development that comes with it. It's important to keep that in mind, because I think it gets forgotten surprisingly frequently, to my mind.
It does, and it's also, so that there's a couple of points that flow from this. The first is, of course, if you at the moment facilitate a change of use under permitted development rights from so it's class MA from E to C3, commercial to residential. Although a community infrastructure levy charge might bite, Section 106 doesn't, which is obviously huge for affordable housing contributions and plays into viability appraisals. But if you are also needing a planning permission for operational development, whilst arguably the provision of affordable housing shouldn't come into that consideration, because you are seeking works notwithstanding the fact of what the underlying purpose is, and that has actually already been authorised. But I've been finding recently that local authorities are using that as the stick to force Section 106 agreements to provide some affordable housing within the completed development. So whilst they shouldn't, some developers have taken the view that actually, because the local planning authority shouldn't be taking that approach, they've negotiated down to quite a low level, but in order to get matters through, have agreed to sign up to a Section 106 agreement attached to the permission for the operational development rather than the change of use. Forgotten what the second point I was going to make was.
I think that's an interesting point on the 106. I haven't come across it before. Local authority looking into it on operational development.
Yeah.
But I think one of the other points for me is, if you're in that situation, well, if you're using a PD right to change use, and E to C3 is a good example of it, because there's a time limit after within which you have to effect that change of use, otherwise you lose the approval. You need to bear that in mind. You need to have commenced the use within that time. It's not enough to have started, for example, the conversion works, if you're making internal alterations, because those internal alterations aren't part of what you have a permitted development right to do. You can do those internal alterations without changing the use, because they're internal, they don't require planning permission. So starting the physical works internally isn't enough. You have to have changed the use in order to have utilised the PD right. And it's really important, and it's a point that quite often gets missed, and suddenly you lose that PD right. And where it particularly gets missed is where you have your permitted development right to change the use, and then you have a planning permission for the operational development you need for external alterations, because you implement the planning permission and sort of mentally move on from the point. You have two planning permissions. You've got one for the works and one for the change of use. You need to implement both within their own relevant timescales. So just the fact that you've started to change the windows in the Zenith example, you've implemented your planning permission to change the windows, but unless within the time limit under the prior approval you have actually changed the use, then all you've done is change the windows in an office block. You haven't turned it into a residential accommodation, and you would need to go back through the prior approval process. Really important point, and one that gets missed so many times, and can become a nightmare when you're then trying to sell the block as a block of flats, and some smart-ass lawyer like us comes along and says, no, it's not a block of flats, it's just an office with strangely residential feel to its windows. So I think a really important point to take away is to always keep in mind your prior approval, any PD right, is itself a planning permission. And so if there is a time limit for implementation, you have to have done what you have permitted development rights for in order to have implemented that prior approval and not to lose the benefit of it.
So there's a follow on from that, and then I've remembered what the other point that I was going to make, and I've made a note of it so I don't forget it again. So following on from that, though, it's quite interesting that obviously, yes, a change of use has to have taken effect for the PD right to bite within the time period for implementation under your prior approval. But does that actually mean somebody physically has to have moved into the house and cooked a meal in the kitchen and watched a bit of Netflix? Or does that actually mean that the works that have been carried out go so far beyond just changing the windows in an office block to the point where the former use could not be reinstated because of the changes made? And the courts have tended to look at everything on its own merits, depending on what's happening. But in the Class MA E to C3 example, if you have completed all the interior works to the point it's quite obviously a house or an apartment or whatever sort of form of final residential unit you're putting in, they have said that actually you don't have to have moved your first tenant in, and they will look at things as well, like, are you marketing it for occupiers to the residential market and that kind of thing. So it's not a case that you need to rush your best friend in to prove that the change of use has happened. But
every one of the flats in order to convert them all across. Not quite.
But it does need to be, substantially complete, and it needs to be quite obvious changes that have taken place. The original point I was going to make, actually, and going back to looking at sort of external changes that might be required, out with windows, whether that's new sort of soil and vent stacks or whatever it happens to be. Quite interestingly, changes to MA were made earlier this year, and it's yet to be seen what the new government, I guess, will do with MA with the reintroduction of mandatory housing targets, because it would seem that actually this class is very helpful for them to achieving that manifesto pledge. But a lot of the previous restrictions on floor space and requirement for previous vacancy before the PD right could be exercised were removed only a few months ago. And at the same time, interestingly, although it wasn't introduced for MA, Class Q was updated, which is the agri to Resi. And in the updates that came in Class Q, now Class Q actually does allow a small amount of external operational development required to bring, for example, an agricultural barn into 5 new housing units. And that is for things like putting ducting for services on the exterior of the building, and for putting new stacks in and things like that. Now, I suppose the rationale may very well be that where you're using Class E to C3, the nature of the building that you're putting those new residential units into is likely to already have services and the like attached, and soil and vent stacks and foul, because there will already be toilets and washroom facilities in there, as opposed to an agricultural barn. But it's interesting how it has been considered, and that may come forward, particularly if the government does see MA as a tool for delivery of its manifesto commitments. That may be something we see coming in the future. Just a thought.
Yeah. I'm conscious of time. I've got a couple more points I think I wanted to cover, but just before I do, we've had a question come through about, if I can summarise the question, because it's quite a long one, but the question effectively is, are PD rights available in the context of residential if the residential dwelling is still under construction? And I think for me, the answer is no, because you need to have built in accordance with your planning permission. If you don't build in accordance with your planning permission, number one, you haven't got a residential dwelling that's completed for your PD rights to attach to. But number two, you'd be in breach of your planning permission, potentially not having built in accordance with it. So there's a chronology to it quite often, and this is probably a good question, because it's probably got quite a general application. But there is a chronology to you need to have carried out the development for which you have planning permission before the PD rights that attach to that form of development attach. And you sometimes see that with changes of use as well. If you've got a planning permission to change use to, say, an office, then you would need to start that office use before you could then sort of move to other things that you might be able to change, use your PD rights for. You couldn't go straight to, well, actually, I've got planning permission for an office, but what I'm going to do is build a block of flats. You'd need to build the office, commence the office use, and then your PD right would apply. But certainly in the context of residential, I think, Sophie, it's pretty clear, to my mind at least, you have to have completed the house before the house gets the benefit of PD rights. You can't sort of go straight from the little house you got planning permission for to a slightly bigger one, because you're going to use your PD rights to expand it.
I think that's right. You have to have a lawful house before you can change the house. I think what would be interesting, though, and I don't think the point's been litigated, but if you were building a house and you practically completed that unit in accordance with the plans before your contractors go off site, so it's built as a house, never been lived in, but actually then you put an extension on, appreciating that might not be commercially that attractive, other than you've already got your people on site, then that I suppose could be considered. Build it according to the plans, then. That's right. But I think it's got to be built.
Kind of the other point on that, the case, I think it's Verndale, I think is the case, but that makes the point that a prior approval or the existence of a PD right in general can be a sort of fallback or a material consideration. Yeah. And I've certainly seen before. I remember doing a case many years ago on a residential property where an extension had been built, and the extension didn't quite come with it. I think we're talking a matter of inches. It didn't quite come within the scope of the PD right. And the local authority, for reasons I never understood, decided to take enforcement action against it. And we couldn't rely on the PD right, but part of our case, we went for a ground A enforcement appeal saying planning ought to be granted. And one of the points we made was, well, if you make us remove it, we can then build exactly the same extension, but just 3 inches smaller. And you wouldn't be able to do anything about it. Therefore, effectively, what is the material impact of the extra 3 inches or whatever it was? And we were certainly successful in that appeal on that basis. So I think that can. It might not prevent enforcement action, but then in that enforcement action, if you do find yourself in that situation, the fact that you could have done it with PD rights, albeit at a later point, may well be a material consideration that justifies sort of seeing off the attempt to enforce.
Yeah, and I think that's important.
One of the other points that I wanted to flag, because I think it's a PD right that is not always understood. Is the PD right that applies, and forgive me, I can't remember off the top of my head which class it is, but if you're granted a flexible planning permission, and by that I mean if you're given a planning permission where you can use planning permission for a a building that can be used either as office or residential. Might be unlikely, but it's the best example I can come up with on the spot. But if you're given that choice as to what use you're going to make of the building that you're getting planning permission for, then there is a permitted development right that allows you to change between those uses. And so you may start, in my example, using it as an office. You have a PD right, unless it's been disapplied, of course. You have a PD right that allows you to flip at a later date to residential, and then indeed would allow you to flip back to office. But I think the point that people miss, and this has come up a few times to me in the context of retail, where back in the days where before they were all in the same use class, you change from shop to cafe or whatever. The flexibility may have been within the planning permission to do that. On the planning permission itself, once you've chosen which of those uses to use, the planning permission then crystallizes. So the planning permission doesn't allow you to keep flipping backwards and forwards between the two. There is, however, a PD right that allows you to keep flipping backwards and forwards between the two, but that PD right only applies for the first 10 years. And so I just sort of wanted to say it out loud because I think people fall into that trap. You've got that flexibility for 10 years, but on the 10th anniversary, whatever the use is on that date, then crystallizes as the only use that you can make. You can't continue to rely on the flexibility of the planning permission, at least, to flip backwards and forwards between those uses. So if you've got those sorts of flexible permissions, you always need to have an eye. And I think particularly, not necessarily particularly, but one of the circumstances which you want to have an eye on it is if you're a landlord and your tenant has the ability to keep moving, ultimately, whatever the tenant is doing in that property on the 10th anniversary is then what you've got permission for moving forward. So that may have an impact in terms of value, thinking particularly in context of rent reviews. At year 5, your rent review might be based on being able to flip between uses, but come year 15, it won't be. And if you happen to have been using the less valuable use on the 10th anniversary, that is the one that would carry forward. So just that was my last thought on that particular right, because it's one that I've seen many times people sort of miss that flexibility does come to an end after 10 years.
Yeah, I think the other sort of factual scenario where that comes up, particularly, it used to be flex between B1, B2, B8, which off the top of my head now I think is EF, former B1 industrial, B2 warehouse, B2 general industrial, B8 warehousing. And quite often you see large units that within a unit might actually have a mix of B2, B8. So you're manufacturing some products and then you're storing them before you go out. And whilst that isn't kind of flip-flopping between the two uses, the same point arises at 10 years. You've got to decide which of the two is the predominant use at that point, because that is what will crystallize. Unless you argue you've then got a mixed use unit, which of itself fine, but again can cause problems if for landlords if you've got tenants coming in that solely want to use B2 or B8 post your existing current tenant at that point, and would you then need to get a planning permission? But also for PDR, because New World payphones was the case in relation to telecoms permitted developments. But actually, if you've got a permitted development right that attaches to a particular use, whether current or former, but actually that use has an element of mixed use within it, the PDR won't attach. So in that case, it was a telephone kiosk that had advertising panels that had been put around it, and they said, no, sorry, PDR for telecoms doesn't attach to what has essentially become a mixed use planning unit. And they were required to go and get planning permission. So, in those, I think particularly sort of industrial, but I can see it in, commercial and Class E situations as well. If you've got various things going on and you want to rely on PD rights, you need to make sure that you're not going to fall into that trap, and that actually the use class that the PDR attaches to is the predominant use, and can be demonstrated is what's factually going on before you exercise the right.
And one of our colleagues has messaged me to say the flexible use permitted development right I was talking about is Class V of Part 3. So there we are. Thank you to Helen for that. Glad someone's awake this time of the morning. We're coming up to our time. So Sophie, is there any other quick fire points you wanted to make?
I don't think so. I think I've covered everything I've written down. I suppose the other point, some PDR rights, although listed buildings are mostly excluded from having PDRs attached to them, some do apply where listed buildings are concerned, and obviously you will still need listed building consent in every circumstance. That's probably the last point. The only other thing I'm going to say, and Trevor is now going to cringe, but I would very much like to wish Mr. Ivory a very happy birthday for today. And I'm sure everybody listening will join with me in wishing you many happy returns.
Thank you very much. You threatened to do that at the beginning, and I thought 57 minutes in I'd got away with it, but thank you for embarrassing me. And what better way to celebrate my birthday than to be on an outline with you talking about permitted development rights? I mean, gosh, I know how to live the high life, don't I? Thank you, Sophie. I suppose 2 final points for me. We haven't talked about EIA, but EIA, if development is EIA development, then that has an impact on PD rights, because you're forced into needing a planning application. And I'd also just say keep an eye on your planning obligation as well, because whilst a planning obligation doesn't prevent you applying for a prior approval, if there are covenants and restrictions there, it may prevent you from implementing it. So they were my last 2 thoughts. But with 2 minutes to spare on that basis, it brings us to an end. So Sophie, thank you for joining me today. Thank you as ever to our audience. We've talked about a lot of cases today. As ever, we will, those who watch the live broadcast, we will circulate the list of detailed references for the cases when we circulate the recording. Those who are watching via the YouTube channel, we will make sure that the notes include details of the cases. But that's it for this month. And in fact, it's August next month, so we get to take our summer holiday, assuming that the UK actually remembers what summer looks like at some point. So we will be back in September with our next episode of Outline. And we're going to go to something slightly different in September. We are bringing in a guest speaker for the first time. I will be joined by Lord Barwell, Gavin Barwell, former planning minister and chief of staff to Theresa May. We've heard much in the few days since the election. We've heard much about planning reform. I suspect over the summer we will hear a lot more. So we're going to sort of get the benefit of an insider's view from Westminster on what those planning reforms look like by the time we get to September, and talking about some of those implications moving forward that they might have for all those of us trying to operate in the planning system. So I hope many of you will join me in September for that. But in the meantime, thank you again and goodbye.
Bye.